see for a second. Doctor, did you do any of the interviews with the families?
I did not.
Okay.
I think he testified he gave direction, and he was a part of this process as to what would be told to the family.
Yeah, but he wasn't there to tell the families anything.
Okay, so I can ask him a different way. I'd rather the witness be excused for this judge.
Okay. You may step out. Go with Mr. Thomas. Remember my instructions. Take us out.
I believe this witness testified that he was involved in the decision-making process to be transparent with these families. I think it is it's clear and proper cross-examination material to explore just how transparent he was with these families.
Okay, but he wasn't the one who gave the discussions directly with the families. How can he testify?
Well,
is there any memorandum of what he testified
Well, I
to?
can ask him if he directed anyone to make these statements.
But then you went into your factual basis there about saving lives.
Well, my factual basis, I have a good faith basis to ask him these questions because they are what's in the records. I'm not making this stuff up.
Okay, then use the records. Okay? You're asking him for what happened at the interviews with the families. And you're trying to back in other stuff. So if it's on these reports, then use them with the person on the reports.
Judge, I think under cross-examination, I can, if I have a good faith basis for the question, I can ask leading questions that ask the specific witness whether or not he disclosed certain information to these patients when claiming that he was transparent. I don't think, I would agree if I lined up, if I wanted to slow it down at a snail's pace, that I could retrieve all of the records and then do one record at a time as a basis for it. But I think I can represent to this court, and if I'm incorrect, certainly the prosecutor has the ability to point out my false statements during redirect and at any point in their case in chief. But I know I have a good faith basis to ask these questions. I've pulled these from the records, and I want to ask him in a leading way whether or not he directed and challenged his lack of transparency to the families in this case.
This isn't the appropriate witness to be asking specifics about what was or was not done in what's contained in these medical records. What this witness has testified to, it was the dosing habits at the time of palliative extubation, which was their concern. That's what the reports they ran are. That's what he is aware of. They want to bring in an expert witness to talk about the care Dr. Husel gave them, they can. If they want to talk to the doctors that were there or the nurses that were there, they can. This is an administrator who came in after the fact, and he is not the appropriate witness to be asking these questions of. He did not participate in these phone calls, as the court has stated. So this is an inappropriate line of questioning, Your Honor.
He's exactly the right witness to ask about this because he's the one coordinating with the prosecutors when and what is going to be told to these families. And he also testified that the reason he did it was to be transparent. And really, that's a bunch of baloney. And the fact that I can't challenge him on it because the prosecutor wouldn't do it that way is irrelevant. I think
he was the one who did the interaction with them. Okay? You don't know what was said? Were the calls recorded?
I don't believe they were, sir.
Okay, so he did not make the phone calls. How can he testify as to what was said on the phone calls?
Because he was a key decision maker as to what would be spoken about in these phone calls. And I can ask him a way, I will ask him in a way that incorporates that fact. didn't actually make the calls, but he directed and was a decision maker as to what would be disclosed. And then he goes and characterizes these phone calls as being transparent when in fact they were not.
Okay, but see, you want your cake and eat it too. You used your words this morning, okay? You want to be able to confront him about his policy decisions, but you want to do it with facts from the medical records. How do you do that logically connected since he wasn't the one who did the interviews?
Because we know what was told to the families because we had scripts. And
Then ask him if he sponsored the scripts.
he testified during direct examination that he went, met with the prosecutors, they made the decisions as to what would not be told to the family members, and because they didn't want to interfere with the investigation. We have in evidence the scripts, which are two different scenarios, one involving a detective reaching out to them first, and one involving Mount Carmel reaching out to them first. He was a key decision maker. That's been established at Project Lighthouse, which includes these scripts, as it related to all of these decisions. So he wants to characterize this disclosure to the families as being transparent. Now that's having your cake and eating it too. If I'm not able to cross-examine him specifically as to what he directed them to disclose or not. Now,
But that wasn't what you were doing. You were sitting there testifying about what was in the medical records. You weren't disclosing his policy. You were confronting him with medical information about recitation and other things. And quite frankly, he's not the person to do that with.
Judge, if I have a good faith basis to ask him about a factor that he did not direct them to disclose, that I think that's a narrow question, a narrow avenue that I believe I should be permitted to go into. Now, I agree with the court in terms of not being able to say that he participated and he didn't tell the family members this. I agree with that. But as to whether he directed anyone to do this because he's labeling it as transparent, I think that is proper and fodder for cross-examination.
Yeah, but even under your own argument, there's a logical offset there because you want him as to what he said, but you're trying to get in what he didn't say or didn't mention, which would be either hearsay or speculation.
What he directed them to say.
Okay, but see, you're not doing it that way.
I agree, and I think...
You're doing it by bringing in collateral facts that are in the medical records that he doesn't know what was said to them. He can't speculate as to what was said.
So let me see if I can do it this way, Judge. What I would like to do is I would incorporate the fact that I have a good faith basis for and ask him if he directed anyone to tell the family members that fact.
We would object.
Still a problem.
Thank you.
You can talk to him about the policies. That's what he was testified to. But to go into the medical records line by line, how is that a good faith basis? You're asking him to speculate what's on the medical records unless he's got actual knowledge.
He does have actual knowledge. He just testified on direct examination. He put this Excel spreadsheet together, and then he did all of this work in reviewing the medical records. He's aware of these facts.
I think the court's made its ruling. May I use the restroom? Thank you.
Yes. Okay. If you want to proffer, I'll step out.
So,
Can Janet cover the proffer?
I'm just...
David?
Janet will cover the proper. If you want to proper.
I was actually moving towards the restroom. I'll cover it.
I'll be right back.
It's all right, go ahead.
I'm step off.
I'm Judge, just so we're clear, you're denying my ability to be able to go into...
I'm denying your ability to use the question format you're in. Now, if you can come up with some other theory that's not speculative or hearsay,
have nothing to proffer, so you can go.
Thank you.
There's shooting, commissioner's garage. Double shooting, commissioner's garage. Taking Roth the suspect in custody. That's that. The problem, they're all over here. 20 minutes for every 12 hours.
I'm attention to the person.
Yeah.